Hi everyone, welcome to Oregon Law Lab.
It's a series where we explore the workplace and how it got to be the way it is. I'm Liz Tippett, a professor at the University of Oregon Law School.
And I'm Jessica Brown, a 3L at the University of Oregon Law School.
Today we're talking to Professor Catherine Fisk, a law professor at UC Berkeley.
Today, as we talk with Professor Fisk, we'll be going on a journey as she explains the evolution of IP law, its shifts, and why we are the way we are today.
And interviewing her will be me and one of our students, Alexander Baker. So, Professor Fisk, this is Alex Baker. He is a third-year law student at the University of Oregon.
Hi, Alex.
Hi, very nice to meet you, Professor Fisk.
Nice to meet you.
Professor, we're so excited to talk to you about working knowledge, and I'm just a super fan of it. And the thing I'm dying to know is, how long did it take you to write it?
About 10 years.
I was going to say that. I think you mentioned in the book you read every judicial opinion that has talked about intellectual property, and I just thought that she means business.
So what was it that made you want to really delve into this topic?
I got the idea for writing the book when I was teaching employment law in the mid-1990s. There were a series of cases in many employment law case books about employer-employee disputes over ownership and control of intellectual property. And I wondered where they came from. I wondered what the history of that area of law was. And it turned out nobody had written on it.
I think when we talk about intellectual property today, we assume it's always been this way, and that companies owned what their workers created. But in your research, you found that actually wasn't true.
Right. It was not always true. For the overwhelming majority of the 19th century, courts and even businesses considered employee-generated economically valuable knowledge to be part of the employee's stock in trade. It was either employee knowledge, which was inseparable from the person of the employee, or it was the property of the employee, and the employer, if it wanted to use it, needed to either keep that person in its employ or to contract with them for the use of the copyright or patent.
So you tell us this interesting story in your book about Dupont. Dupont is a huge company now. Workers at Dupont invented things like nylon stockings. They invented Kevlar and bulletproof vests. They invented Teflon, the coatings that you see on pans. But your book has this great story about how DuPont's intellectual property was handled back in the early 1800s when the company was really just this one guy who was trying to make gunpowder out in Delaware. Can you tell us about that?
DuPont was founded by a French aristocrat who fled the French Revolution and found himself in Delaware. His principal claim was that he had studied chemistry under the great French chemist Lavoisier, and that he had a better way of making gunpowder, an always valuable commodity in the war-torn United States of the early 19th century. And so he hired people to work in the gunpowder manufactory that he had there on the banks of the Brandywine River. You can still go and visit the property. It's actually quite beautiful, and that's where I did the archival work. And competitors wanted to know why his gunpowder was of a better quality than theirs. So they went to some effort to figure out what techniques he used to make the gunpowder, including recruiting one of the people who worked in the DuPont powder mill to leave DuPont and go to his powder mill, taking with him a sieve and a brass pounder that were used to mix the gunpowder. And these things sound kind of silly today, but if you think about it, the United States was incredibly short on technology in the early 19th century. and very short on both the devices that were useful to make things, but also the knowledge about how to make things. And the English restricted the export of their technology to the United States because they wanted to prevent themselves from facing competition from cheap labor overseas. Sound familiar? In any case, the competitor recruited away a couple of DuPont employees by meeting with them in a tavern near the DuPont powder mill and persuading them to leave DuPont and take with them the pounder. DuPont was furious and discovered that he had few legal remedies against the recruitment of his employees. He did hunt them down and beat them up, or at least his friends did that for him. Not a satisfactory way of resolving these disputes. And to DuPont, this was treachery as well as an outrage about the failings of American law, because he believed that the manufacturing of gunpowder was based on his knowledge, his expertise, and also that he had sort of a property right in the knowledge of his workers, because he believed what they knew they learned from him. Obviously, the worker and the competitor saw it differently. They saw this knowledge and skill as being the property of the employee who possessed it, who should be free to leave one job and go to another if he found better working conditions elsewhere.
That's one of the things that kind of surprised me when I was reading this book, was to see that you mentioned historically creative employees have enjoyed substantial legal control over their ideas or their patents or their copyrights or other valuable economic ideas that they possessed or came up with. This is the exact opposite of, I guess, what a regular Joe Schmo like me would think, that's not familiar with intellectual property. Can you tell us more about that? How was this?
I think, as I say in the book, the reason why courts, employees, and even employers tended to treat intellectual property as the property of the employee who generated it was both because it made sense to regard the patent or the copyright as being the property of the person that invented it, both on a sort of a moral sense of it's like your strength, it's like your intelligence, it's like your creativity. That is, it's either an attribute of you that is inseparable from you, or even if it is separable, it should be yours because it's only just that it be so, like any other property. We don't come in and take your house away. Or for instrumental reasons. That is, if you want to encourage people to be creative, the whole intellectual property law in the United States is always about a series of incentives. And so it was important to not eliminate the incentives to be creative by immediately divesting creative workers of their rights. I think it was also important to many that people be able to attribute the work to the person that created it, because it was a form of branding. It was a form of sort of vouching for the reliability or the source of the information. And so the attribution function played an important market function in a way that it still does today. If you think about screen credit in Hollywood, attaching the name of a celebrity writer or director to a product is hugely valuable to market the product. And that could be true for patents or copyrights, or indeed unpatented and uncopyrightable material as well.
So that concludes part one of our session with Professor Fisk. Jessica, what are your thoughts?
I thought it was really interesting that she was able to shed light on the transgression between common law and where we are today in terms of initially owning the attributions of your creativity and then having to contract into it.
Right, and in the next episode, we'll learn more about how the law switched from a default where free people own the work they created to the employer owning it. So don't forget to subscribe if you want to check out the next episode, which we'll post in the next few days.